Well, I have to say, thank you all for inviting me. I'm not quite sure what's going to happen today, but when I talked with Pam in the beginning, we were talking about the various kind of measures of accountability in responding to domestic violence and sexual assault, stalking, et cetera. And as I started thinking about what I could bring to the discussion, I was trying to think of an analogy about when you're trying to do an intervention, how can you determine if something is working? And how do you put together a process that's going to work, however you decide that you're going to define that? And I started thinking about baking bread. And when you bake bread, you have a recipe, and you gather together the ingredients, and you have to mix them all up, and then you have to pound it down, and then you have to let it raise, and you have to pound it down, you have to let it raise, you have to put it in a warm place. Eventually, you put it in the oven. You turn on the oven at the right temperature. You leave it in for the right amount of time, and when you're done, you have a loaf of bread, right? So we don't have anything that works quite that routinely when we're thinking about accountability, increasing safety for victims, especially high-risk victims. But what we do know is that if we were going to bake a loaf of bread and we poured all the ingredients in a bowl and stuck the bowl with the ingredients in the oven, we probably wouldn't get a loaf of bread. And I think that when we look at how to respond to domestic violence, we have to understand that what we're looking at is a process, and that there are many steps to the process. And each of those steps has to be carefully considered in terms of what is the impact on victim safety of this step of the intervention, and how does this enhance the system and the community's ability to hold offenders accountable. So that's how I'm kind of going to frame what I'm going to talk about this morning, and I'm going to do just kind of an overview of where we are in the country in terms of responding to IPV, and especially high-risk IPV. We have these steps that need to be institutionalized in our multi-agency responses. And my belief is that there is a institutionalized steps that are integrated into each part of the intervention, and that there's a role for trying to look at what kind of violence is going on, what is the risk to the victim. There are multiple places to safety plan with the victim based upon the information you gather from identifying risk, that you have to coordinate multidisciplinary strategies. And by that I mean, what happens in pretrial and how that informs bail, and then what information the prosecutor has when they go in order to look for sentencing or for pleas, and how we're going to manage the threat. And that through all of this, we're going to be also looking at not just the threat posed by the offender to the victim, but many of our institutional practices also pose barriers to victim safety. And those kinds of things have to be identified as well. So, it's a multifaceted response that brings about the best results. We have a big push in our country right now, nationally, to look at how do we identify high-risk offenders. About 10 years ago, I started really paying a lot of attention to this whole topic of risk assessment, danger assessment, lethality assessment. We know that each of these different kinds of tools has some overlapping criteria for identifying high-risk offenders. And so some communities have decided to implement a certain tool here, a tool there. And we have people calling us all the time saying, what tool should we use? And, I really encourage communities to step back and let's talk about what is it you really want to do, and why are we looking at using a tool? Part of the whole process, apart from the tool, is we have a criminal justice intervention response. And at each step of that response, starting at 911, we have an opportunity to integrate risk factor identification into institutional practices. There are questions that and protocols that can be put in place starting with 911 that can start to identify high-risk factors that will both inform law enforcement when they arrive as well as be helpful and facilitate the safety of the officers. When you get each of these intervention steps or processes to start identifying risk, then you have to figure out how we're going to document it. And how is that documentation going to be institutionalized? If 911 finds something out that could indicate high risk, such as let's say the person is a combat veteran who has PTSD, if we don't have a way of documenting and ensuring that this information goes to the next intervener, it's like we don't know that information. And so as you can see, we're looking at really institutional practices that have to be developed, implemented, and monitored to start sharing this information about what are high-risk factors and what are we going to do about it once we know that information. So I always talk with communities about what do you really want the information for? What will you do with it once you have it? And once you figure out what you want it for, then that'll help you decide what kind of a tool you want to use. Some of them are going to measure how soon can we predict with some validity that the offender is going to reassault? How severe will the reassault be? Others are looking at what is the particular danger of lethal violence for the victim. We also have to figure out where we're going to get this information about high risk. As we know, we can get them from public records, police reports, criminal history, probation, protection orders, violations of protection orders. We can get information directly from the offender. We can get information from the victim. We can get information from a combination of sources. Each of these has pros and cons. Each of these can help provide a picture or tell the narrative of what is going on in this particular relationship, in this assault, and what's the context of the assault. I'm going to talk just a little bit about tools and protocols that are the most common ones that are in place in the United States. Lethality tool, we have the danger assessment developed by Jackie Campbell over many, many years ago, which has been validated and updated through time. This was a tool that was developed to be used originally in a health setting between a health worker, a nurse probably, and someone who had been identified as a victim of domestic violence. There are currently validated danger assessments for working with immigrant women. There is one for lesbian women in same-sex relationships. And all of these are interactive conversations that someone who has been certified and trained to do a danger assessment can perform with a victim. It helps them identify kind of what are all of the behavioral markers that have been evident in the relationship to assess how potentially lethal this might be. Then there's the lethality assessment protocol, which came out of Maryland. It's been around now for about maybe a little over 10 years. And the lethality assessment protocol is a shortened version of the danger assessment developed by Dr. Campbell. It's a two-tiered questioning. Police identify risk by asking questions of the victim when they respond to a domestic violence assault. And through that, they determine if the victim is high risk for lethality. The most important part of the protocol, I think, is that it involves connecting high-risk victims with advocates right at the scene. And this is probably one of the strategies that I think promotes the most safeguards for victims. There's a lot of research and evaluation that's out there that has been done on the lethality assessment protocol. And what they can tell you is the victims are screened for high risk that are connected with the victim by the phone. Anywhere between 60 and 70% of those victims go on to seek services from an advocate, whether that's some sort of legal advocacy, shelter, going to a support group, having a conversation with an advocate. It seems in the preliminary evaluation to be a protective factor against future violence. There's a significant rate there. So it doesn't take a lot of resources other than training your police officers, training your advocates. You may have to hire more advocates. But it's one of those protocols that put in place and start that process immediately of identifying who's at high risk. There are other tools being used by the criminal justice system that focus on identifying or predicting recidivism or severity of future assaults. One that's being used is ODERA, and that's being used in various communities. It's another assessment tool developed in Canada. It links victims with advocates, and the information is also used to inform other intervention strategies such as bail, levels of bail, conditions of release, used throughout. And the information from the ODERA is then, disseminated throughout the intervention process so that the other interveners also have access to that information. The thing I like about the ODERA is that in addition to identifying risk, it has a question for law enforcement to identify if there are any victim vulnerabilities in addition to the risk posed by the person who has abused the victim. And that could be that the victim is poor, they have a lot of children, they don't speak English. There's a variety of vulnerabilities. Of course, that involves training for the police to be able to, use their judgment in terms of identifying victim vulnerabilities. I'm going to talk about the DVSI, is the Domestic Violence Screening Instrument. It was developed in Colorado over 10 years ago, I believe, and it was used to predict recidivism and used as a bail assessment tool. There have been quite a few communities who have taken up the DVSI and used that to identify, is this person going to reassault and how bad is it going to be and how soon is it going to be? There are other tools that do not have a DV focus that are used by corrections for bail evaluation, but they do not necessarily capture the same kinds of factors that predict domestic violence recidivism. SARA is spouse abuse risk assessment, also developed in Canada. It's more of a psychosocial evaluation. It takes a longer time to do it. It relies on public information as well as an interview with the offender and interview with the victim. In some communities, such as here in Minneapolis, they use a combination of the DVSI and the SARA, and I think someone from Minneapolis is going to talk about that a little later on. So once we identify who's at risk and what kind of risk we're looking at, then we have to figure out what are we going to do. And I think that this is a place where many communities are wrestling or ignoring what to do. It's like we're all excited because now we have a risk assessment. Now we can tell you this victim is really in danger. And then I say, so what are you going to do with that information? And they're like, well, that's the part we haven't really figured out. So fortunately, we have some good initiatives going on around the country. High-risk teams, which is a multi-agency case management team that involves members of the criminal justice intervention, as well as domestic violence advocates, sometimes social workers, sometimes child protection. Communities do it differently, but it's basically once you identify a high risk, you're going to get together and figure out what kind of additional or enhanced safety planning strategies will be needed, and how are we going to hold this offender accountable, how are we going to contain them, surveil them, etc. One of the newer is offender-focused deterrence, although many years ago we had one called targeted abusers. I think it's kind of similar to that. in that from the very first arrest, they start focusing on the offender. How are we going to monitor and contain this offender? They have a matrix that they use in order to identify, how particularly dangerous is this person. They have law enforcement talking to the offender. I'm not going to spend more time on this because I know you're going to deal with that later on. And, of course, we have domestic violence response teams, a whole variety, whether they're called DVRTs or DARTs or whatever they're called in various communities, where they have developed or implemented a response. Most of them include advocates responding with police officers to the scene so that the advocate can provide on-scene support, safety planning options, and resources to the victim. And so we have different things going on all over the country, but not consistently. And usually not everything is going to happen in one place. When we talk about doing a risk assessment, of course, we know that the victim has the best information and the victim has the best story. And often when I train criminal justice practitioners about risk assessment, everyone wants to go to the victim. And that's the main thing they want to do. And I say, I understand why you want to do that. But I think that when we rely just on, or mostly on, information that we get from the victim, and when we're using this in a criminal justice intervention, especially when we have a document completed and attributed to the victim, if this becomes part of the court record, we have a whole other set of issues that have to be considered. And you have to have protocols to kind of lay out what's going to happen. Is this information completed, given to you by the victim, attributed to the victim? Is this going to become part of discovery? Is this something that the abuser is going to see, the defense attorney is going to see? Who has access to this information, both now and later? And is the victim fully informed about who is going to see this information, have access to this information now and at a later date? We had a community that called, and a judge had gone to a danger assessment training. He came back and said, I want every petitioner who comes in front of my court to get an order for protection to complete a danger assessment. That danger assessment was stapled to the petition, and when it was served to the respondent, the danger assessment was with the petition. We found that to be somewhat problematic. And you're thinking about, we have this danger assessment now attached. We've got time between the serving of this petition and the ex parte order. How is the respondent going to be responding to this information that's attached? How could this possibly be used by a criminal defense attorney at another date? And there's just a lot of things to think through. So I always tell people, if you're going to just go for the danger assessment, make sure that you think about all the ways in which this information can be passed on to other people and what could be the possible consequences of that. Let's see. Okay. So I think the best response in terms of holding offenders accountable is not to jump to the last step, which is batter's intervention, but to go through the whole intervention response, a multidisciplinary response in which we are making the intimidation and control visible, both our risk factors, that we're identifying the context and the risk of the violence. As we know, not all violence is the same. That's why we're sitting here trying to sort it out. Which of these victims is going to need the most in terms of safety precautions? Which offenders do we really need to, contain, monitor, surveil, et cetera? The other thing is that none of this means anything if we don't have a system that ensures a consistent accountability and that increases the sanctions for increased risk posed to victims. I have done so many safety assessments in various jurisdictions. And one of the things we do is we read prosecution files and court records. And when we go through the court records and we see, in some cases, I'm just going to give an average, let's say 10 arrests for domestic violence. And each time that there's time for court, right, it has been continued. And in the meantime, there is another assault, right? And then it's continued. In the meantime, there's another assault, right? And then maybe there's another assault. And instead of having increasing bail, they're just released on their own recognizance and don't do it again or come back at a later date. If there was time hanging over them for a previous case, sometimes that's just rolled into a new case. And so there really isn't any certainty that there are going to be swift and certain consequences in terms of accountability for offenders. You know, it leads people, often they want to ask, you know, why isn't the victim cooperating? Why isn't the victim part of this process? And I always say, because there is no certainty, right? There's no consistency. We can't tell a victim that, you know, if this person offends again, you know, that we will actually, as the system response, take steps to ensure that this doesn't happen again. The multidisciplinary, the response has to engage the victim. And so we have to be offering support and help. That's why I like the protocols that hook a victim up with an advocate right away. No matter what kinds of services you have available, some of those, or one of those services, has to be a confidential service, a confidential advocacy service, where the person who is talking to the victim and getting information from the victim is working for the victim. I think that people, the victim liaisons or victim rights people, advocates, they offer a really great help, especially understanding the criminal justice system, supporting them through the process. They do usually work for the prosecutor or the police, and when they do, that's who they work for. And so I think we have to be ensured that we're making sure that the victim has confidential advocacy services as well. We have to say that we understand that when they are coming to us for help, whether they've called the police or someone else has called the police, whether they ask for help or they've been referred, that they have an increased chance for reassault and potential danger for retaliation or for asking for help. Research has shown that asking for help ups the ante in terms of high-risk behaviors from the offender. We also have to understand that there's a disparate impact in our communities and a disparate impact from interventions. I was talking with Oliver Williams about this. He said, I'm not concerned how many African American men are getting arrested. What I'm concerned about is the other men that aren't getting arrested. Or maybe we're arresting the wrong people for the wrong things. And so I think we have to, as we go forward, always look at the fact that this multidisciplinary intervention is not having, a different impact in marginalized communities. And also we have to be constant in looking at our intervention to identify unintended consequences. I know there's a lot of advocates in the room, so I know you know, and I can probably point out many unintended consequences that have happened just as a result of our criminal justice intervention. Things we didn't want to have happen, but it did. And so now we need to look at, as we go forward, if we're going to initiate new protocols or practices related to responding to high-risk cases, what could be the unintended consequences from those actions? Fortunately, because we've been responding to domestic violence for a long time, we've had some trial and errors in terms of what is a good response throughout our country, that we have some best practices that we can now say it's a good thing. Research has shown this is a good thing. We need to do it. It works. There are many communities in the United States that still are not consistently using predominant aggressor determination when making arrests. They aren't held accountable for not making those predominant aggressor determinations. It's not the norm that communities have policies around enforcing existing firearms prohibitions. It's not necessarily the norm that we have consistent enforcement of protection orders. We passed a lot of laws. We came up with a lot of protocols and policies that we say this helps. Research has shown that some of these do actually help deter further assault or increase risk of assault. And yet we have not, as a country or community, sometimes even within a county, been consistent in enforcement of practices that we know will help. So that's one of my closing current limitations of how we're currently responding to domestic violence is that we don't have anything consistent across communities in terms of how we're going to identify risk factors. We don't have a process to collect and document risk at each step of the intervention. We may have, in some communities, sometimes the police are doing a risk assessment, but that's kind of the end of it. The risk assessment information does not go on further to inform the other parts of the criminal justice intervention. We have many jurisdictions that say, yeah, we want to use a tool, but we're going to adapt it and change it, or we're just going to make up our own tool. Well, all I can say is that that tool is not valid anymore, and it may be questions you think are important. There's a lot of people who think we have to ask about alcohol. Alcohol is part of lethality. Well, actually, research-based information tells you that that's not true. Use of alcohol on the day, if they have been escalating use of alcohol, there's some nuanced things about alcohol, but there are some tools that people have spent a lot of time developing to predict recidivism or lethality. I encourage communities to use those. And we also have, my big red message here is that accountability measures are not consistent. It's difficult to get increased sanctions. It's difficult to get probation revocation. Monitoring court compliance for conditions, enforcing the law, enforcing protection orders. We have a long way to go in terms of utilizing the measures that we have put in place to hold offenders accountable, in addition to intervention. So that's kind of the end of my overview of where we're at in terms of accountability, managing threat and identifying risk. Does anyone have any questions?
So Connie, as far as tools that de-emphasize getting information from victims,
Yes.
It's really just the court records and evidence gathered around a perpetrator. Is that where they focus? Is there anything that gets the perpetrator on the record, for instance, or I don't know if I'm making sense.
Well, you have yes and no. Okay, so you have the police report, and then you have the questions that are asked by the law enforcement officers. Those are generally supposed to be part of the record. We have in the DVS, the domestic violence screening instrument, that is used pre-trial. And some communities use it pre-trial. Some of them use it in terms of developing pre-sentence recommendations. They do ask questions of the perpetrator there. And we have a lot of public information, and there's a lot of research that shows the best information is the information we already have, that comes from public records, what happened at that incident that the police are responding to. The SARA also does an interview with the perpetrator. They're not always the most forthcoming and accurate reporters on their own behavior, but we do have this other information that can give you some facts around that. And in fact, several of those don't require much information from the offender at all. And when you're talking about measuring recidivism and severity of assault, you can get that information from a tool that doesn't a lot of information from the victim. But I also want to clarify here when I say getting information from the victim, asking a victim information that's part of a process like the DVSI, the SARA, even the lethality assessment program, the protocol, the LAP. You know, you're asking questions of the victim, but it's not like the whole body of information is going to be attributed to the victim. You know, there's some information, and plus it's coming through a translator, whether that's the probation officer, the police officer, someone else who is collecting information. I think that that's really different than handing the victim a piece of paper or a list of questions, and then having them identify that, yes, I wrote this, I answered these questions, this is my information. So I think it's all in the process about how you gather the information and, you know, how it can be directly attributed to the victim, and in what situations you're going to use that information. It's a long conversation. You know, I always want to bring it up when we start talking about getting information from the victim.
Me?
I can't see you, but I can hear you.
Oh, you can hear me. So with the ODARA, is that
Yes.
mostly based on criminal history? I can't remember whether that includes victim information or not.
It does have some victim information, but not a lot.
Yeah. Okay. Thank you. Go ahead.
I have a little question and a smaller question and then a bigger question. The smaller question is, have these tools been validated among Spanish speakers? Like Latino immigrants?
I didn't hear the last.
Among Spanish speakers, such as, you know, Latino immigrant communities, which is the community we serve?
You mean the danger assessment or the others?
Have they been validated on those communities? Because you said there were evidence. These are, you know, I was just thinking about what you said about the inconsistencies and things have been validated, and I was just wondering if, because I'm not aware that all of them have been translated into Spanish, and I just was wondering what kind of validation they have had among minorities.
You know, I don't know the answer to.
Okay, and then the larger question is.
I don't know the answer to.
Okay, thank you.
But I have one thing to add, is that the danger assessment has been, according to Dr. Campbell, is valid on African American and with Latina victims. So I'm sure they have translated it into Spanish. And she says that it has been validated with those populations. The other tools, in terms of the criminal justice tools that are used, I don't know about that.
Thank you. I found this is excellent and a really great overview. And this is probably beyond your presentation, but how can we take steps? I mean, to me, what this is pointing to is a coordinated community response. And so, do you have ideas for how a community like ours can take steps to become more coordinated in our community as a response, or is that beyond your presentation?
No, well, it's beyond my presentation, but it's not beyond my work, which I'd be glad to talk with you further about. One of the things I can tell you is that BWJP, where I work, is a national resource center on the criminal legal response to domestic violence. And we have developed a set of what we call checklists. And it's looking at each step of the intervention, starting with 911 and going all the way through batterer's intervention, in terms of what should be in place, in terms of identifying risk factors, documenting them, passing them on to the next intervener, acting on them, consistent protocols. So we have a whole big packet on those, and if they're not up on our website, they will be soon, but I can give them to you, send them to you, talk with you about how to use them in your CCR meetings or in your community, and I'm sure you have my contact information. I'd love to talk with you more about it.
I have a question. I'm over here in the corner. These arms right here. Thank you so much for all the information that you presented today, and it's helpful to hear all the efforts around the country and also internationally. It's always just universalizing, that the struggles are similar community to community. So I'm just curious, any guidance you might have or thoughts on, we as a task force are looking to make recommendations out of all the information that we get. So I'm hearing that what you're saying, that a community needs to be consistent in its response, but I'm wondering what your thoughts are on community to community. Do we need to be consistent, or do you believe that each community should be left to its own devices to come up with what works locally? Or do we need to have something that's looking at this is how we do it across the state or across the country? Or should we advocate for kind of autonomy in each of our areas? Or do we need to be looking at this is how we all do it, and what is a stronger stance?
Oh, that's really an item of debate right now. I think because every community is different, right? Some things have to be tailored to a community. Because we have, states' rights in terms of legislation, we have, 50 different sets of laws on the books that, are in place already in how to respond to domestic violence. Some of them are pretty good, some of them are great, some of them are horrible, which, already sets kind of a context and limitation on what some states can already do. But in terms of identifying risk, I think that every community can start doing that and then can look at how are we going to ensure that within the laws that we have to deal with, that we can have swift and certain consequences and increased sanctions. And how can we enhance our ability to work with all victims and understand that, as we know, what often keeps a victim from being safe has more to do with factors outside of the offender even, in terms of, things like language, access, disabilities, immigration, a lot of different factors. That's basically, the advocates have to push the system to do a better job with marginalized victims. And that to me is a local effort and a state effort and a national effort, depending on, what you're engaged in. So I think that if you're looking at New Mexico, at least one thing you have consistent is you have the same laws throughout the state. You probably could come up with some recommendations for what New Mexico should do. There are states that have come up with protocols, quite a few actually, Massachusetts, Maine, Vermont, Utah, in terms of how they're going to identify risk, how they're going to use that information. And you have to kind of coordinate that and start looking at long-term, what is your statutes around bail, how is that related to severity of assault. I mean, it's a big plan when you're looking at a state plan, to address each part of the intervention.
I have a question. Connie, you talked about, we talked about the assessment protocols, and I was wondering, in my recollection, all of those are specific to a specific couple dyad. So the assessment of risk is for a specific couple dyad. But in the review of homicides, we often see a pattern of history of abuse in a couple dyad, and then the abuser goes on to commit an act of homicide in a new relationship. Do any of these risk assessments assess the propensity for the offender to continue acts of domestic violence or escalate domestic violence regardless of who the victim is? Do any of these assessment tools address that issue? And if not, do you have any recommendations for how we might do that?
Well, I know that past acts of domestic violence are part of several risk assessment factors that are measured. So it does take into account the fact that the person has been violent in the past with another partner. But in terms of predicting whether they're going to go on to be violent with another partner, I don't know of any tools that specifically predict that. I may be wrong, but I don't know of any.
Thank you, Connie.
Thank you.
Thanks, Connie.
Thank you.